Well, welcome. It's a very nice big turnout. We're going to talk about, well, we is not really quite accurate. Ben is going to talk about wills and trusts and probate. And I'm Julia Wald. This is Ben Gale. We are both estate planning lawyers, but I'm retired. So Ben is going to tell you all about this, and I may chime in from time to time. And I want to know if you have what you need. Maybe you're going to want a pen and be able to write. You have pieces of paper. We have some handouts here. We have more pens up front. And I think I'll turn it over to Ben.
Okay. Well, thank you.
And this is being recorded, so for whatever that's worth.
Anything you say can and may be used against them.
Oh, must be lawyers here.
Okay. Well, I put together this outline last night, kind of hoping that it would be a useful way to introduce the subject. I sort of started with sort of a cynical approach, which is, do you need to do any kind of an estate plan at all? And as I got to thinking about it more and more, I said, yes, you probably should do an estate plan. There are good reasons for it. And even though you're not going to be around to appreciate the benefits of the plan you've created, other people will, and that probably will make you feel good right in the here and now. So I'm going to skip most of the introduction that I prepared, which was all about how rules have been around for literally millennia to help societies figure out, or help individuals and societies figure out what to do with the leftover assets of the person who has left them. For example, who gets to sleep in that corner of the cave under those nice hand paintings on the wall. That's something that has to be decided. Who gets the cudgel? Who gets alley-oop's cudgel when he's no longer with us? And those laws have been around for a long time, and they're fairly detailed. I mentioned them in the first part of my first section of my outline here, under where I mentioned Hammurabi's Code. Hammurabi's Code goes back, as you can see, to the 1700 BC. So people were writing quite detailed rules about about where your assets should go. One I've had to deal with myself, and Hammurabi's Code proved to be quite relevant on that issue, is what to do with, let's see, when someone dies and you're the child of his first spouse, but he has a second spouse who also has kids. You may have run into that situation yourself. It's an inevitable source of conflict. I don't know whether you're first spouse or second spouse.
Or no conflict, because you've gotten it all worked out ahead of time with a good lawyer who makes it absolutely tight, and then there's no conflict. Because
I don't know. I think my father's lawyer charged by the word, because his documents didn't help at all. Anyway, so there are reasons to do an estate plan, even though it's not going to benefit you personally when it really comes into effect. And I mentioned those two. Peace of mind is sort of what occurs to me. And I think Julie and I talked about this briefly. You get some peace of mind just because people who are around you now know that there's some plan to take care of them, and hopefully they'll understand a little bit what it is. I think Julie is suggesting that this is something that you need to think about pretty carefully, because it can be surprising how much conflict can arise after someone dies among beneficiaries and family members who were all pretty copacetic up until that point.
Unless you're an estate planning lawyer, and then you're no longer surprised.
Right, because you see it every day.
Because you see it every day. Yeah. And my sense is the conflict is often about, of course, it's often about the money, but I had a family fighting over a 50-year-old vegetable dish that was made of China, maybe. So it is also about who did mom love most. So if you can write your documents so that everybody is treated equally, and that's going to go a long way to, and when you're choosing the executor or the trustee, that you don't just choose the oldest male. Maybe you choose, what I often recommended was you say, I want Sam and John and Matilda, my 3 children, to be executor, or the ones of them who want to do it. And then you're not the one making the choice, they are. And then they're less likely to be fighting, because they're still fighting for mom's attention. If your goal is to make sure they're not fighting, you would do it equally. If you have other goals,
Sometimes there's one child who just needs more support than others, and hopefully everyone takes that into account, and the plan reflects that, that additional need. But I think I agree with Julie. I leave it up to my clients, but generally speaking, I think the best way to avoid dissension is to simply say I love you all equally, and so everything I have is going to go to you in equal shares. Can you hear me okay? I'll bring it a little closer.
I can hear. But raise your hand if you're not hearing us, because there's really no point in sitting here listening to a lecture that you can't hear.
Right.
So we can talk more into the mic and we can talk louder.
So let's say that you've decided not to just let things happen the way that they happen when you don't make a plan. That is to say, let's say you've decided to actually make an estate plan. What should you do first? What should you think about first in deciding the basic outline of your plan? Well, I think the answer is to look at everything you've got. Determine what you own and what's going to happen to it. In our business, there's kind of a sharp line drawn between assets that are considered part of your estate and for which you have to make a plan, and assets that are not considered part of your probate estate and for which a plan already has been made or for which you don't have to make a plan. So if you look in my section 2 of this outline, your assets of your probate estate are going to include everything you own, except for things that are already sort of planned for. Those of you who have IRAs or 401ks know that there's a provision in the plan, it's in the IRA document itself, or 401k, that says who that's going to go to. And I suppose part of estate planning is deciding whose names are going to be on that list. Yes? Mm-hmm. It might or might not include beneficiaries. It might just say it goes to your estate. Okay, so I need to look at it. You need to take a look at that and see which side of the line that falls under. So that question is, what if you're not sure whether your retirement asset, mutual fund or whatever it might be, contains a provision saying where your assets are supposed to go when you die? And the answer there is, well, you got to look at it to see which side of the line it falls under, whether it's a probate asset or a non-probate asset. If there's a beneficiary listed in the paperwork for the retirement asset, then it's not considered a probate asset. It will go automatically by operation of law to whoever's name is on that list, or names are on that list. The second thing you need to do is, identify your real estate. One we'll get into this in a minute, but real estate is treated differently from other assets in estate planning because there's a long and complicated procedure for transferring real estate that may or may not require the help of a court of law. So, I mean, you'll know whether you've got real estate, and if you do, you'll identify it. And if you're working with an estate planner, you'll tell him about it, and he'll help you decide how to plan for it. Okay, so we've come this far. Once you've identified what you've got and whether it's considered a probate asset or not, now you get to decide what basic kind of a plan you're going to use. And I entitled this handout that I gave you, "What is best, will, trust, both, or neither?" The way people typically pass on their assets is either through a will, a trust, both, or neither. Neither has a name in our business. Does anybody know what the name for the passing of property owned by a person who has neither a will nor a trust or other device to pass on his or her property? Julia knows. Intestate succession, that's right, yeah. So there are a whole series of laws in our probate code that say where your property goes if you die without leaving a will or setting up a trust. And for many people, that's probably all they need. Now, there's some advantages to writing a will, even if you have a limited number of assets. The basic rule for intestate succession, as you can see here, is that no probate is required if there's no real estate and your other property, which we call personal property, is worth less than $166,250. Don't ask me how they came up with that number. I think when Julie and I first started this business, that maximum was in the neighborhood of 25,000 or 30,000.
Yeah, 20 or 30. Yeah.
Yeah, and over the decades, it's increased to the point where 166,000 is considered small enough that the court doesn't have to deal with it, and you don't need a lot of formal protections to pass it on to other members of family. If you don't do anything at all, the laws of intestate succession will kick in, and they simply provide that everything you owe goes to your spouse, goes to your spouse and next of kin. I don't know if we need to get into the percentages, but basically it works something like this. If you're married and you have one child, then half of everything you own goes to your spouse, and the other half goes to the one child. If you're married and you have more than one child, then 1/3 goes to your spouse, and the other 2/3 is shared equally among your other kids.
But I think all your community property goes to your spouse?
No.
No?
Her one half of the community property is still hers.
Okay, but
your one half of the property is
gets
treated
divided between you.
just like all of your
Okay.
other property. Yeah.
But if you have it in joint tenancy, it goes directly to whoever the co-joint tenant is. So that's very useful. This is just an aside. It's very useful if you have a lot of debt. If you have everything in joint tenancy and you die, there's nothing to pay the debt, which you might want to pay the debt, but you might not. So
I've actually handled a case like that for
I
a
did
client.
too.
You did too.
the husband was a gambler and
Exactly.
he ran up all this debt.
Exactly. Just before he died.
Yeah.
Yeah.
And so, because the rule about joint tenancy is you own it together while you're alive, and then you inherit it. Whoever survives the two of you inherits it, and they inherit it at the moment of death. So there's no time it's available for the debtor. Yes.
Okay. The question was, what is joint tenancy?
Sorry.
And joint tenancy is listed among one of the things you take a look at when you're deciding what kind of an estate plan to have. If you have everything in joint tenancy, it simply passes to your joint tenant when you die.
That's what it is. It's a way to hold property.
It's a form of ownership. We have bank accounts, the joint accounts. Those are generally speaking joint tenancy accounts. If you have a bank account held in both names where both people have access to it, and one of you dies, then the survivor gets the entire account. And what Julie is suggesting is there are circumstances when you want, or your spouse wants, your survivor wants everything in that account, and they don't want to pay your creditors, particularly if those creditors were acquired frivolously. And what we say is that the account passes to you by operation of law, passes to the survivor by operation of law, and the creditors do not get to attach the account. There are other kinds of forms of co-ownership, which are called co-tenancies, but they are not necessarily joint tenancies. We have something called tenancies in common, which are simply percentage interests in an asset. It can be a piece of real estate or an account of some kind in which you, let's say, it's owned 50-50. Well, your 50 is separate from your tenant in common's 50%. And so if you're holding, let's say, real property as a tenant in common, then your share is subject to the claims of your creditors, but the other tenant, the interest of the other tenant in common is not subject to the claims of your creditors. I guess that's about all I want to go into about forms of co-ownership. Yes. Yeah, that problem does come up. If it comes up in the, I'm sorry, yes, excuse me. The question was, what happens if you have a piece of property, often a undeveloped lot, which has been passed from one generation to the next or one set of hands to the next without title ever having been changed? And the answer is that you got to go back and get title changed. And that usually means opening a probate, I think. I've run into it a few times, and that's been the way that we've handled it. There is a rarely used probate proceeding that allows you to transfer real estate of relatively small value. And this used to be $20,000. I think it's typically referred to as, modified probate proceeding for real estate of less than $20,000. Well, that $20,000 is now $61,500. I looked it up last night. There is a simplified probate proceeding where you can go in, file for probate in the name of the person whose name is on title to the deed, on the title to the deed, and you don't have to present a will. You don't have to have. You don't have to deal with creditors, which I'm going to get into in a minute. You just simply have to have a real estate specialist come in and identify the property and confirm that it is the property that it's said to be. And then the judge can simply say, okay, this person is passed on. Here is who is supposed to receive the property from his or her estate.
But I think you might have to do that simplified procedure for each of the people who had died. So you have to get it from grandpa to wife, and then you have to do another one, wife to daughter, and then daughter to granddaughter.
That's what I was thinking. So I told her, get death certificates for everybody.
Yes. She said get death certificates for everybody.
And then look and see if anybody had a will.
And then look and see if anybody had a will. Right.
Yeah, I mean, I'm thinking through this while you're talking, and that's probably right. If the person was alive when the holder of the property died, then yes, the next of kin, I should say, then it would pass to that next of kin, and then you would need to do some kind of simplified probate proceeding for that next of kin if they're deceased. Hopefully, it can all be done at once. I've never been involved in one that complicated.
And it's out of state.
Okay.
Well, then the property is out of state?
That's in North Carolina.
Yeah, so you're going to have to follow North Carolina rules, and anything we said doesn't apply.
Yeah.
What is probate?
Okay, so the questions that are being raised is, what is a POD account and what is probate? So I'm sure that Ben is just about to tell us.
Right, and I skimmed over the what to do first section a little too quickly, I think. A POD account is a pay on death account. And it's
As in a bank account?
typically a bank account. You can go to your bank and say, I want this money to go to, my son or my nephew when I die. And so they put his name on the account. And then if they're provided with a death certificate, they'll simply turn those funds over to whoever name it is, who is listed as the pay on death person. And doesn't need to go to probate, no fuss, no muss. TOD accounts are, you know about TOD accounts? A TOD is a transfer on death title.
I figured.
It's typically used for real estate. It's a simplified way to transfer real estate without having to go and open a probate proceeding. And you've asked what probate is, and I'll get to that in a second. But just for now, just assume it has to do with the court. Without opening a probate proceeding, and it's a deed that simply says, upon my death, this property goes to so and so. And that also can be done with minimal fuss. The county recorder will accept the deed, and you come and bring the death certificate, and with the new deed, transferring the property to your own name, and it can all be done outside of court. Okay, so we talked about probate assets, and why do we use the term probate? Probate is a term we use to describe a situation where the property has to go in front of a judge. The estate has to go in front of a judge to decide what happens to it. Probate is, it's a pretty ancient form of taking care of decedent's assets. It's painstaking, it can be protracted, it can be expensive, it can be burdensome, onerous to the eventual recipients, and we're going to get into why people prefer trusts, and that's one of the reasons. Trusts help avoid probate in most cases, and the cost and the delay and the public exposure and everything negative associated with having to take something before a judge and prove up whatever documents it is that you're making the transfer with. So that's probate. Probate just simply means having to do with the proceeding, that's handled in this building right next door, or excuse me, a couple blocks over, where there's a judge appointed to, let's get into that. I think we're okay. We're done with intestate succession. I'll take more answers on it, questions on it later if you want to get into it anymore, but I think we've talked enough about it already. That figure of $166,250 is the critical figure, and most people these days are above that. So most of you are going to be needing to think about whether you want to do a will or a trust. Okay. So who handles a will? Who is the person who's going to handle your estate under a will? Do people know what that person is called in the law? All right. That person is called an executor. Or in the old days, they used to say executrix if it was a female. I don't know if that distinction is still being made. But even an executor doesn't automatically get the job. If someone is designated as an executor in your will, then he or she has to take that will to a court of law and do what we call lodge it, present it to the court, and more or less ask the court to approve both the will, confirm that it wasn't forged or obtained by undue influence or written by some person who didn't lack the competency to write it, and also to get approved as the executor, because the court gets to have a say in whether you're sufficiently trustworthy, would be, I guess, the main thing. Trustworthy to serve as somebody's executor, even if the dead person, whom we call a decedent, has designated you or has named you in his will to serve, his or her will to serve as executor. And who manages a trust then? If we have all our property in a trust, who would manage that for us after we're gone? But the answer there is a trustee. And that's the basic distinction that surprisingly many people get confused by between an executor and a trustee. An executor is a person who's appointed to administer a will. The trustee is a person who is designated to manage the trust, to administer the trust. As I mentioned, some of the advantages of it, well, maybe I haven't mentioned it, some of the advantages of a trust are that no probate is usually required. I was thinking about it this morning, and it's almost the flip side of a will, of a probate. In a probate, you have to prove up everything. You have to, as I said, prove that the will is valid, that the executor is competent to administer it, all the creditors have been paid, that the executor, before he distributes, has adequately accounted for everything, has done a formal inventory of everything in the estate for the benefit of the court. And judges can be quite fussy about that. They take their jobs of protecting the public interest pretty seriously, and these damn things can drag on for a long time, particularly if you have one person who isn't happy with the terms of the will and chooses to contest it in court. A living trust, on the other hand, and I'm using the term living trust because that's the kind of trust that most of us have heard about. That's the trust that your estate planning lawyer is suggesting that you set up for yourself. It's a trust where, generally speaking, you're the original trustee. It's meant to be invisible. You're transferring your assets into this entity, which we call a trust, but you're retaining the same control over them that you had when you just held it in your own name. If you put your bank account, for example, in the name of yourself as trustee of such and such a trust, then you can access those funds and do whatever you want with them the same way you could when the bank account was under your own name. The same with your real estate, your home. If you want to sell it, you simply sell it as trustee. You put your home into the trust name. You say, title to this property will be held by Julia Wald as trustee of the Julia Wald Trust and any successor trustee if I am kaput. And then Julia Wald, as trustee of her own trust, can transfer the property to whoever she wants to, buy it, sell it, whatever.
But when I become incapacitated, still alive and incapacitated, somebody else becomes trustee. And maybe we're going to say this, but that's one of the advantages because people do become incapacitated. And if you don't have your property in a trust, there's the danger that then you have another court proceeding called a conservatorship where somebody gets appointed and then they get to manage your property. But if you have everything in a trust and you say who the successor trustee is, then when you become incapacitated, the successor trustee can be taking over and managing your property without a court proceeding.
Yeah, if you're looking for this in the outline, it's the very first thing. It's the very first thing I mentioned is that actually, I have this a little out of place. I should say that trust in particular avoids the need for a conservatorship because if you're incompetent, if you're beyond the point where you can manage your own affairs at all, someone is going to require that a representative be set up to handle your affairs for you. If you've got a trust set up, that will by default be the person you've named as trustee. The trustee will already be in a position to take over your trust. I don't know about Julia's trusts, but they usually say that if you're determined by two doctors who are not related to you by blood or marriage, then that's sufficient to require change of trustee, to require that you be replaced as trustee. Usually doesn't come to that. Usually people, voluntarily step down if they no longer feel they have the capacity to manage their own trusts. But yes, that's one of the primary reasons to set up a trust, is to protect yourself from that, potential problem, which, let's face it, is happens all too often with our, progressively aging population. We stay alive, but sometimes, we no longer really have the competency to manage your own affairs. So I suggested you think of a trust as being like a separate entity. It isn't in a way, because it's invisible, and as I said, you get to manage everything, and nobody will contest your authority or right to do what you want with your money and your property. But like a corporation, if you step down as the manager and somebody else steps up as the new president, if you will, of your personal corporation, he or she has all the powers that you had. He or she steps into your shoes. So it's choosing a trustee is an important part of the process, and I spend a lot of time on it. I think Julia does too. You want someone who's appropriate to do it. If you're losing your competency, if you're starting to fade, maybe you don't want a family member or family members to step in as trustee. Maybe you want to hire a professional trustee, or maybe there's some person that who would just be perfect for the job, and better probably than your children to handle your day-to-day affairs. Your children are busy with their own lives, and being trustee for someone who is incompetent, it can be a pretty demanding job.
And so do you know that there are professional trustees? I think a lot of people don't know that. There are people who are vetted, and their whole job is acting as trustee for other people. And then also most banks are willing to be trustee. I just want you to be aware that there are also individual people. And so if you're talking to your estate planner and you think you want someone who's professional at it, like if your kids are at loggerheads already, maybe you don't want to appoint them both to be trustee and working together. Maybe you want to have a professional and you're not so keen about, to name one, Wells Fargo Bank. So you say, okay, I want somebody who knows how to be trustee, and I don't know what to do. Ask about individual professional trustees. They're licensed, they're monitored, and your attorney should be able to point you, and then you go and interview them and see if you like them.
Yeah, I think the estate planning councils of most counties have a fair number of competent trustees. At least that's been my experience in Marin County, and I'm sure it's the same in San Francisco County. And you can get a referral to a good professional trustee. Sometimes they have a staff. Sometimes it's one trustee and 3 or 4 people doing a lot of the legwork for them. Sometimes it's just one individual trustee who establishes a personal relationship with let's call him or her the trustor, the person who set up the trust, the owner of the trust, if you will. And, that may be the preferable option. As I said, it's something you think through quite a bit. Even if you don't go with anybody other than your family members, it is important to think about how they're going to react to one of them being appointed trustee over another. And this can cause, some strife that you don't want to cause when you're gone. Julia suggests a procedure which I prefer too, and that is to name them all as prospective trustees, and then let whichever one of them doesn't want to do it just drop out. If that way, it's kind of the kid's choice as to who's going to administer your estate, and if they want to be in there and to watchdog, all of the financial process, the paying of creditors, and the memorial service and all that, they can do it. Otherwise, if they're comfortable with one of their siblings handling most of it, or two of their siblings handling all of these administrative tasks, they can simply say, I decline to serve as co-trustee.
Is the same thing possible for executors on wills and their professional executors?
Okay, the question was, are there professional executors? Is it the same way that they're professional trustees? And I think you can get a professional executor, but I am not familiar with any. They aren't like professional trustees. They don't have an organization, at least as far as I know. Maybe Julia knows of.
I would have thought that the people who are licensed to be trustees would also be willing to be executor.
Yeah.
But
yes, I would
again,
agree with
if you get referred to them or you find one, just ask. But
Yeah,
I think that, like Deborah Dolch, I think she did both.
If you have a trust set up, then the trustee is probably going to do everything. And they're probably going to be named as executor under your pour over will, which we're going to get to in a second. But if you don't have a trust set up, it can be difficult to, and you don't have an executor, it can be difficult to find one. Sometimes the court has to appoint the executor. Sometimes it'll be a court-appointed executor if there's no other appropriate person, family member, relative, friend, whatever, to do it. Okay, so the next item on my list is a trust better than a will? And we've been through these issues a little bit already. The probate takes a minimum of about 6 months. The probate takes a minimum of 6 months to probate a will. I don't think I've been involved in one that only took 6 months. Have you, Julia? No, it's usually quite a bit longer than that.
I would count on at least a year.
Yeah.
And I've been retired for a while and retired before I had to do many cases since COVID. And it seems that getting a court date is taking longer and longer. So you start a probate and your petition, you file this formal piece of paper that's mostly pre-printed, check the boxes, please probate this will, and I bet it takes you 2 months to get a hearing. And that may be an exaggeration, but it will take at least 1 month to get a hearing.
I think here in San Francisco, yeah, at least 2 months, yeah. Question?
Ben, is now a good time for me to lift in the air the thing I showed you earlier?
I don't think we're going to get into the details of how each typical revocable trust is written up. It takes a long time to go through it, and Julie and I are just kind of covering the hot spots. But maybe when we're done, we can look at it as sort of provide an illustration of how. Oh yeah, go ahead and hold it up in the air. This is.
Hi, I'm Karen.
Karen and I had a discussion earlier whether it was a good idea to. Okay, so this is a revocable living trust. Using the terms revocable and living, it's a little bit of a redundancy, but these trust mills do that. The law uses the term living trust or revocable trust interchangeably. They're synonymous. I generally do not recommend going to a trust mill to get your trust work done. There are 1,000 ways that things can go wrong, and if someone is, processing your information, and I don't know, a half-hour interview or whatever, he or she is inevitably going to miss something, and it can cause tremendous problems later on. I'll just give you one example. I had an estate where everything belonged to one spouse. She and her husband went to a trust mill to set up a trust and decided who they wanted to give their assets to, and both of them were gone. They had some charities in mind, some friends. Husband got sick and died. Things changed, and surviving wife, no longer wanted to give money to these same people. In fact, she was estranged from these people. But because her trust mill had not put in a provision allowing her the flexibility to change it, in other words, to take all of the property from her husband's share of the trust, give it to herself, and then have her decide what she wanted to do with it, she was stuck. And these so-called former friends have plagued her and her new boyfriend or new spouse for the last 10 years. So anyway, that's just one of a typical problem that can come up with a trust. Often the tax consequences aren't properly thought through. So if it's a very simple trust and you have a limited number of assets and all you want to do is have something and you don't want to pay a lot of money for it, then I guess it's acceptable. Otherwise, I can't recommend going to a trust mill to have your trust work done. Anyway, getting back to is trust better than a will? One issue that comes up a lot, and I think it's the first thing people think about, is how much is this going to cost me? Do you all have an idea of what lawyers and executors typically charge or can charge to administer your will?
What we're talking about the cost
in
of probate?
probate court, yeah. If you have to have your will probated. It's 4% of the first 100,000, 2% of the next 100,000, 1% of the next 800,000. Did I say that right?
Yeah.
And hang on, what is it? 1% after that. Hold on, I got my notes and I knew I would mess this up, so I wrote it down.
And you pay this both to the lawyer and to the executor.
Yeah, so let me start over again.
So it's twice.
4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, and 1% of the 1% of the rest up to $1 million. So let's take an example. Say you have an estate worth $2 million. What do you think it will cost you in terms of
Worth how much?
$2 million?
$2 million.
$2 million. And this, by the way, is $2 million gross. Let's say you have a big mortgage on the house, so that it's really the whole estate is not worth $2 million, and maybe you've got some other secured debts, but the gross estate is worth $2 million. How much do you think that would cost you in terms of executors' fees and lawyers' fees?
I don't know.
The answer is $33,000 for each.
So $66,000 on this $2 million estate, which isn't really a $2 million estate because you had $1 million in debt, but it gets counted as a $2 million estate for purposes of calculating the fee. So say you had a house and you had a $500,000 mortgage, you're still going to be paying these fees for the whole $1 million house.
Anyway, so
that's why, even though a trust can cost a bit of money to get drafted, most estate planning lawyers say what you really want is a trust, because it saves money. It's at death. It saves time at death. It saves you possibly having a conservatorship before your death. And the conservatorship itself is very expensive because it's another court proceeding.
And the conservator gets paid quite a substantial amount.
It could be your daughter and she didn't take a fee, but
Unless it's a friend or family member.
But there'll be a lawyer, because again, it's one of these procedures where you do a petition, it goes to the court, you have hearings at court, the lawyer, in conservatorship, the lawyer can't just charge whatever they like, they have to take a petition to the court and say, here's what I spent time on, here's what I accomplished, here's what I want to be paid, and the court can say, yeah, that's too much. Or they can say, okay, you did a good job.
So your trust attorney is going to charge you some money to take you through this process, both to draft the papers and to assist the new trustee, the successor trustee, in administering the trust after you're gone. But it's not anything like $66,000 for a $2 million estate. Even at $500 an hour or whatever lawyers are charging today, you're typically looking at quarter to a third of what you would pay to probate the estate in terms of what you have to pay the trust lawyer. Another thing people sometimes object to is that a probate proceeding, splashes all of your information on the public record. So I can go online for any decedent from the city and county of San Francisco, who died in the city and county of San Francisco, and get all kinds of information just by putting his number into a search program that the court has, and get all the documents about the value of his estate and who his family is and where they live,
And read the will.
and you can read the will. Correct. Yeah. So if privacy is something you value, then trust is far superior to a will, because a trust is not published anywhere. That's private information between you and your family members, or you and the other people affected by it. And we have a question. Okay, so the question was, are there ongoing costs for administering a trust during your lifetime? And are the people who help administer the trust paid during that period? And the answer is, if you're managing the trust yourself as trustee, your costs are the cost of an occasional phone call to your attorney to get some trust question answered. If you have your trust managed by a third-party trustee, then yes, there are going to be ongoing costs throughout the rest of your life, based on the amount of time and work that the trustee puts into managing the trust for you. The fourth item in Section 4 of my outline is that trusts are harder to contest, and I think this is true. There's no hard and fast.
And
proof
by
of this.
contest, I think you mean challenged whether it was done properly, or let's get rid of it, or whatever.
If somebody doesn't feel like they got their fair share, or that your trust doesn't really do what you intended it to do, and you're no longer around to challenge that, or to respond to that challenge, is a trust more likely to survive a challenge than a will? And the answer, I think, is yes. I've been involved in a lot of trust litigation, but the competency and the rightness of the trust itself is rarely ever questioned. And the reason for that is the trust is usually written years before the person has died. And after 4 or 5 years, whoever's challenging it just can't get evidence anymore to show, or to try to prove that the trust was not prepared, according to Hoyle, that the trustor was not subject to undue influence or lacked capacity at the time that he wrote it. And to my mind, it's a good thing. I mean, if you do a trust and you read it and sign it, you want that trust to be binding. You don't want somebody to come out of the blue and say, oh, I'm somebody that was forgotten and you would have meant to give me money if you'd known about me or something like that. Because more often than not, that's not somebody who has a good claim. I don't know, Julie, do you have any comments on that?
No.
Yeah. The last item had here is tax planning. And this is kind of an important issue. It comes up pretty much every time that a married couple does a trust together. What if one spouse dies and the other spouse, the surviving spouse, doesn't want to live in this big house anymore, wants to move it someplace smaller, wants to sell the house and pay the minimum amount of taxes? Well, if you're holding your property as in joint tenancy, okay, I'm going to take one step back. Ordinarily, all property that you hold in your estate receives what's called a step-up in tax basis when you die. And what that means is that anything you own, your house, for example, is treated as if your successor bought it on the day that you die. So, for example, you may have bought your house for $100,000. Now it's worth $1 million. If you sell it during your lifetime, you're going to be taxed on $900,000 of capital gain. I'm subject to some exceptions, but basically that. If the house passes to your beneficiary, your spouse, whoever it might be, on your death, then it's treated as if the property was purchased for $1 million on the date of your death. And if your spouse subsequently sells it, at least before it appreciates more, there's no capital gain tax on that. This is a huge benefit to surviving spouses. And if the property is held as community property without a right of survivorship, and one spouse dies and it's not held in a trust, then only the half interest of the spouse who died is stepped up. So in our example, if you bought your house for $100,000 at the time you die, each of you and your spouse are deemed to own $500,000 worth. The tax basis in your $500,000 is stepped up to $500,000, but the surviving spouse's tax basis is not. It's one half of whatever the property was originally purchased for. So in the example that I've given you, you will have the surviving spouse will have a tax basis in this property of $500,000, representing the interest of the decedent spouse, plus her $50,000. So her basis is only $550,000. She sells it as for $1 million. There's a $450,000 gain, a taxable gain that she has to deal with. As I say, there are some exceptions, but even with the exceptions, the tax on the surviving spouse can be pretty hefty. You have any comments on that particular problem?
No, that's the problem.
Yeah, I have a question.
Does a living trust have to file a tax return?
The question was, does a living trust have to file a tax return? And the answer is, while you're alive, no. A living trust is revocable, generally. Let's just say it's revocable. We have other kinds of trusts called irrevocable trusts, but that isn't what we're talking about today. If you're interested in doing a more complicated irrevocable trust for some reason, you'll talk to your lawyer about it. But these are trusts that are just designed, these living trusts, irrevocable trusts, are just designed to be invisible and to take the place of a will. After you die, then the trust does become this separate entity, and now it's a separate taxable entity. And so, yes, after you die, then the living trust becomes irrevocable, and it does have to file a tax return. But the tax consequences can be handled. The tax consequences are usually not onerous. Okay, the next section is what documents are used in an estate plan. You go to your lawyer and he hands you some papers. What papers can you expect him to give you? Well, the answer to that is the trust document itself. Do you give your clients a form for trust, or do you just ask questions? You have a questionnaire and fill out the trust yourself and then give them a draft once it's in draft form?
Well, and after talking to them, I give them questionnaire beforehand, not so much that they'll fill it out. Actually, I don't do this anymore because I'm retired, but in theory, that's what I do. You give them a questionnaire so that they know what questions I'm going to be talking to them about when they come in for an interview, and then they come in and we talk about it, and then I send them a draft, making certain that every name is spelt correctly, because
It's embarrassing otherwise.
that's very embarrassing when it happens otherwise, and that, of course, is something that they know how to check for. So anyway, so you send them a draft, and then if they like it, you just have it done up in final form, and they can come in and sign it and have it notarized. Or they may have changed their mind, and so then we change it.
Julie, how long is your typical trust? How many pages?
42 and a half pages.
42. I had 20 to 40, so she's thrown in a couple of extra pages. I've seen them as long as 80 pages long. Mine are typically 20 to 30. So obviously there are a lot of questions answered in that trust, which are not ones that are posed by either you or your attorney. The trust is full of boilerplate, and necessarily so. There are all kinds of problems that can come up, all kinds of questions that can come up during your lifetime and after you die, and the trust is intended to provide an answer to any of the questions or solve any of the problems that could come up. Trusts incorporate a fair amount of the probate code, at least mine do. The terms about what the trustee can do.
To give you all an idea, just think the trustee is limited by California law as to what they can and can't do. So the trustee may not be a professional, and they're wondering, so now what? I don't know what I'm supposed to do. So the trust document may have the limits to what they can do and the advice to how they can do it, so that it's in the document that they're trying to follow.
That's a good way to put it. The trust is intended to answer all of the trustee's questions, even if he or she is a layman. And he or she may contact her attorney to get more specific information or further details. But basically, it's all there in the trust. So there'll be some things in it that are going to make your eyes crossed. You're going to get bored reading it.
So you'll look and make sure the names are spelled correctly when your eyes are.
Some people read every single provision in the trust and ask you questions about it, which of course you can answer because you've done a million of them. But other people you just tell them, okay, here is the portion that tells you how your property is going to be divided up. Here's the portion that tells you who your trustees are going to be. Focus on those, and don't worry too much about the rest of it. Okay, so that's the main document. That's the main thing. The second thing the attorney's likely to give you is something called a durable power of attorney. Does everyone know what a durable power of attorney is? Have you run into one of these? This is a document that allows somebody else to step into your shoes if you should become incapacitated, or not, if you're unavailable. And when I say step into your shoes, I mean really they can, depending on what you provide in here, what authority you give them, they can do anything or they can do very little. Most people just check put their initials next to the line that says all of the powers, potential powers listed above, and the form, goes into some detail. You can find this form very easily online. I did it myself. I'm not going to make copies of it for you. It goes into a fair amount of detail about what all of the different things you can do to help your principal, which is what the person who sets up the power of attorney is called. You're the agent, he is the principal. What your principal authorizes you as agent to do. And they can check just a few of the powers, or they can check, the principal can check just a few of the powers, or they can check all of them. And if it's a spouse, for example, and you're in good terms with the spouse, you're typically going to just give them carte blanche. You'll just check the box that says, let this person step into my shoes if I become incapacitated. This may avoid the need for conservatorship that Julia mentioned before. I'm really not sure of the point at which a power of attorney is no longer sufficient. The point at which you actually have to get a conservator appointed to administer your, and if it's as broad a power of attorney as you could possibly.
Yeah, I think the conservatorships I did were either when the agent, that's the person who's acting in place of the person who signed the document, when the agent turns out not to be honest and somebody else steps in and says, we really need a conservator, so there's some supervision. Because you understand that the agent operating under a power of attorney can sell all your property, can pay all your bills, can change what you invest in, supposedly not take the money for themselves, but
it happens.
This power of attorney is not supervised by the court. They're not being required to do an accounting to someone else. So if I become incapacitated and my agent is operating under this power of attorney, they can do whatever with the money, and I can end up having no money. So
selecting
that's one point at which, hopefully earlier than when I have no money, a conservator would come in. But I don't think the conservatorships that I did were where people didn't have a power of attorney.
So
well, and sometimes where they were being stolen from, yeah.
So the takeaway points here are that under a power of attorney, your agent can do virtually anything you can do individually. And if you have a power of attorney, it's unlikely that you're going to need to have a conservatorship. The second point is then that the agent you choose to serve as your agent has to be somebody that you trust, maybe even more than the trustee of your trust. This has to be a person that you trust your life to, literally. Okay, the third document.
15 minutes.
We get to 15 minutes left, but we're just about there.
Yeah. I know.
The third document is something called a pour-over will. We said a few moments ago that if you have a trust, you don't need a will. You don't need to go to probate. But what if you inherit a house and you die a couple of weeks later before you have an opportunity to transfer the property into your trust? What are your beneficiaries supposed to do? This house is in your name, and it's not in the name of the trust. Its title is not to you as trustee of this trust. Trustee is to you, Julia Wald. And the answer to that question is, well, they have this document called a pour-over will, which allows them to open a probate for the limited purpose of transferring this one item to your trust and then having the trustee administer it the same as all of your other assets. And it also applies in situations where you just forget something. Something just gets left out of your trust. You have some account and some mutual fund of a couple $1 million that you forgot about, forgot to put in your trust. Or maybe your attorney didn't get around to putting it into your trust. So anyway, the pour-over will allows you to transfer that property into your trust. Hopefully without, yes, I have one question.
Is the trust instrument recorded or filed somewhere, and how does anyone know it's a real thing?
That's one of the miracles of the whole trust business, is that it is not recorded anywhere. Nobody needs to know about it other than the people who are using it and the institutions that they're dealing with, the banks and financial institutions, the recorder's office. But most people just accept that it hasn't been forged. It's a strange situation. You have this 42-page document that often is not signed or even initialed on every page. Sometimes the signature is only on the last page, and it's notarized, so that's some proof that it is in fact what it appears to be. But in our society, that appears to be all you really, it seems to work. These trusts are rarely challenged on grounds that they've been tampered with or made up out of thin air. So anyway, I hope that answers your question. The last item is Power of Attorney for Healthcare and Advanced Healthcare Directive. And those are actually two different documents. Some attorneys don't even know that. Somewhere along the line, the legislature created this document that both tells your physicians, your healthcare providers, what you want to have happen to you if you're no longer able to tell them, if you're incapacitated in some way. And it also appoints a person to serve as your agent to make healthcare decisions for you when things come up. What drugs do you want? What heroic measures do you want to keep you going for some period of time after you become critically ill? Those kinds of questions which you can't answer beforehand, that have to be dealt with on the spot, and they get used a lot. It's surprising how often it comes up that you have a client who's either lost his capacity or goes into a coma. I mean, you don't like to think of it happening, but it does happen, and somebody needs to be there to answer those questions. And it helps the doctors a whole lot if they have a statement by you saying how much, what you want in the way of drugs, what you're allergic to, what have you. So I just mention it because it's an important document, and if you don't have one already, you should. It's one of those things to put on the list to do, before too much more time passes, and provide a copy to your local hospital, because that's likely where you're going to end up if
And your doctor.
And your personal physician, yeah. Okay, the last item I have on here, second last. Second last item is what gifts can you make from the trust? And this is just kind of a technical question. I said earlier that a trust is sort of invisible. You're the boss. You control the show. You're the king of the castle or queen of the castle, as it may be. And so you can make gifts from your trust. And
While you're trustee.
While you're trustee. If you're not the trustee, what happens then? Well, most trusts don't provide for the trustee to make gifts, but sometimes they do. I often put a provision in there saying that, if I've established some, and this used to be quite common, I've established some pattern of gift giving to family members to reduce the size of my taxable estate, back when estates used to be taxed, that the trustee can continue making those annual gifts of $14,000 per beneficiary or whatever it might be. The second point has to do with gifts to caregivers. There was a famous case about 15 years ago where a lawyer wrote himself into the trust of a whole lot of his clients, in which he left himself some money. And sometimes it was a lot of money, and he had a lot of clients. So that came to the attention of the legislature, and they passed a series of code sections to try to keep that from happening again. It particularly comes up in the case of caregivers. Caregivers can be very influential with the person they're taking care of, and often the person wants to leave them some money. I mean, sometimes it's with a little bit of encouragement from the caregiver, but often it's a matter of gratitude. And So those kind of gifts can be done, but you have to get an attorney involved, and not an attorney that has had anything to do with that caregiver. He has to be completely independent and hear why you want to make the gift and whether it's appropriate, and then he'll sign something called a certificate of independent review, saying that it's okay, it's perfectly acceptable for this person to make this gift.
I need 1 minute at the end.
Okay. Okay.
It's okay.
The last thing we've got is, and we've already talked about the basis step up for the surviving spouse. Last thing we get is tax consequences. A couple of small points here. If you transfer your house into a trust, there's not going to be any property tax increase. It's a tax-free transfer. You're still considered to be the owner for tax purposes. That will change, of course, when you die, and if we want, after we're done, we can discuss what happens under Prop 13 and the laws relating to parent-child transfers. But I'm not going to get into it here. That's something for your attorney to discuss with you if you go that route. And then there was a special problem related to a non-citizen spouse. Maybe none of you have non-citizen spouses, but it used to be a problem because the non-citizen spouse was not entitled to what they called the marital deduction. Most of us can leave whatever we have to a spouse without there being any estate tax imposed on it. It's automatically entirely exempt, and just because it's a gift to a spouse. That particular exemption doesn't apply in the case of a non-citizen spouse, I guess because the legislature was afraid these people were going to take off for Sweden or Liberia or wherever they're from and take the assets with them and somehow avoid, taxation by under the U.S. tax system. That problem, that problem is no longer a serious one because the state tax exemption is so huge now that it covers pretty much most of the, let's say the estates of 99% of us. The current exemption is $13.6 million. So you and I can leave $13.6 million to whoever we want.
I'll take it.
Without there being any tax on it. Now, Trump kind of jumped this up a few years ago. It was much smaller than I remember what it was. And it's supposed to sunset at the end of this year. It's supposed to go back down to about 5 or 6 million.
Let me assure you, there will be new legislation.
But we can expect, without even hearing anything tomorrow, that there'll be some initiative to keep that $13.6 million tax exemption per spouse, by the way, per person in place. So $26 million for a married couple. Okay, that's all I've got, Troy.
It will be higher.
That's all I've got. So I'll leave it to you to wrap up. Question.
The property basis step up, is that applied only to a spouse? What if there's no spouse?
It applies to anyone. As long as the property goes through the estate, then it gets a step up in basis.
So if you give me your house that is worth $1 million, give it to me through your will or through your trust, then when I have it, it's based, even though you bought it for $100,000, now I have it, it's as if I had bought it for $1 million, if that's what it was worth when you died.
But don't leave Julia any property unless you go to an independent attorney to confirm that it's okay.
Is this Q&A?
Yes, it is.
Yes,
We use this?
yes.
This makes it easier.
But before we get all into questions, there's one thing I need to say, or that I would like to say. Some people who are members of this church leave gifts to the church to be in effect when they pass away. Sometimes it has happened that the church didn't get those gifts because we've been talking about a trust, and we've been talking about how only the people who happen to have the trust in their hand actually get to see what's in the trust. So if the church doesn't know that it's a beneficiary of my trust, and whoever is managing my trust after I pass away doesn't show the church that the church gets a gift, the church won't get the gift that I want them to get. So correct me if I'm wrong, Vanessa, but I think what we want is for people who do leave the church some money that you let the church know. What?
If I can follow up.
Yep.
So let the church know, ideally, what you've put in the trust, even give us a copy of the document, and who your executor is, right? Is that the name?
Yep.
Trustee.
The trustee. So who to contact, because the last thing we want to do when someone passes away is call their family and be like, you know, we also miss Jane. Jane said she left us something, and say it, right? Except to the person whose responsibility it is to execute on Jane's wishes. That person has assumed that responsibility, and so that's an appropriate person to go to. And as someone who just did a trust in my own family, I will also say that I was encouraged by our lawyer not to give copies to everybody who was included in it, because it might change and then they might get their feelings hurt. So let me also just assure everybody who's here or watching this later, you are welcome to change your trust. Just give us a new copy. And if we're cut out of it, that's fine. We understand things change. Church is not the number one priority for you, or our values have changed, or you just see that a top priority is saving the planet from burning up and not the church or whatever. Or if obviously the trustee changes, let us know. But I want you to feel the comfort to know your wishes will be respected, and we understand that you have the right to change your trust 1,000 times. But we have had a couple of occasions, even since I've been here, where the person said very clearly that the church was in their will or trust, and then we don't hear anything. And it's super awkward. We don't know who to call. It feels, you can imagine, right? You feel really vulture-like, but you also thought their wishes were something about the church, so you also want to respect that the way I would want my wishes respected.
And let me just, for horror stories, add that it helps to be giving the copy to the church, because while what Vanessa said, we aren't going to have our feelings hurt, sometimes it isn't really your wishes to change your document, but you have a caregiver who is persuading you. And we've had cases, members of the congregation here, who have been in that situation. And if the church had known that the document had been changed, that would have been a red flag, and they might have protected the congregant from the caregiver. So there are multiple reasons. Yeah, right. But the more that the people here at the church know, the better.
Now that I'm thinking about it, I think the church or other charitable beneficiary is the only beneficiary I would give a copy of the trust to.
Yeah.
And it makes complete sense to
And if you're not comfortable, or you're talking to some other congregants and they're not saying, I don't want to give this document to anybody, if you just let somebody here at the church know that it is your intention to make a gift to the church at your death, and who the trustee is if you have a trust, or who the executor is if you have a will, then your wishes are more likely to be actually carried out.
Question.
Yes, I have two questions. The first one is, it sounds like what you're saying is if I have a trust, and let's say my son is the only recipient, it's better for him to sell my place, because if he doesn't, I bought it for $100,000, it's now worth $1 million. If he doesn't sell it soon after I die, then he now has to pay taxes on $1 million property. Is that correct?
Not quite. His tax base,
So we're talking about capital gains tax.
he will be treated as if he bought that property for $1 million.
Right.
He can sell it whenever he wants. He only has to pay the tax on the profit, the difference between $1 million and what he sells it for. So if he sells it right away, he pays zero in tax. If he sells it when the property is now worth $2 million, he pays tax on $1 million worth of appreciation. but he's gotten the benefit of that appreciation, so he has very little to complain about.
Okay, and the second question I have is, my son died, and I want what I would have given to him to my grandson. So I own a house in Benicia with my daughter-in-law, and so when you say joint tenancy things cannot go into probate, that particular property could not go into probate. Is that correct?
Yes, if it's held in a true joint tenancy, the property will pass by operation of law to the other joint tenant or joint tenant. Sometimes you can have multiple joint tenants.
But if you don't want your half of the property to go to your daughter-in-law, you want it to go to
My grandson.
or your grandson, then you don't want it in joint tenancy. You
Okay.
want it as tenants in common, and then your estate planning document says, as to my half of the house in Benicia, I want it to go to my grandson.
Okay, yeah, thank you.
Okay?
I had one other comment on gift giving to the church. I have run into this before. Some charities, I don't know about the church, but some charities encourage what are called charitable remainder trusts, which may be appropriate for some of you, and I'll just sort of give you the basic idea how they work. The idea is that you give some asset upon your death, or you promise to give some asset upon your death to the charity. I guess it could be the church, although I doubt that this church has a program set up for this. And then you receive back income. And many schools do this, for example, colleges will pay you back some income on money that's irrevocably promised to them upon your death. You keep the property, and it's a source of income to you for the rest of your life. The equity in the property itself goes to the charitable beneficiary when you die. Charitable remainder trusts are talked about a lot, but done kind of rarely. Although I think they can be a good idea.
Well, they also were a way to get out of paying estate taxes when you die, and now that the amount you can have is big enough that maybe they're not so useful. Yes, Vanessa?
I don't think we currently have any, but I believe the denomination has a program that they help congregations access. So if somebody wanted us to consider that we would have, the denomination would help us set it up. That's my understanding.
Yeah, I think
okay.
that's my understanding.
It's kind of like a reverse mortgage, I think, in that respect. You're giving somebody the property away, you're getting back money to support you in return.
So, thank you all for coming. Come again, and if you want to talk to us individually, we're here.